The issue, as you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint.
Those were some of the remarks from U.S. Supreme Court Justice Brett Kavanaugh during the hours-long hearing into the validity of Louisiana's congressional map. At the heart of the issue, does the map, which created a second majority minority district drawn under the Voting Rights Act, violate the Constitution? So what does it all mean, and how did we get here in the first place? I break it all down. What's at stake, not just for Louisiana, but possibly the nation. Louisiana's controversial congressional map is back before the U.S. Supreme Court Wednesday, October 15th, in a case that could fundamentally alter how voting districts are drawn across the nation. The justices are examining whether Section 2 of the Voting Rights Act conflicts with the 14th and 15th Amendments to the Constitution, according to Louisiana State Representative Stephen Jackson, who was selected to watch the proceedings.
They're trying to see, does the Voting Rights Act and the way we draw maps, does it violate the Constitution with regard to the 14th and 15th Amendment?
A years-long legal battle reaches critical juncture. The legal dispute has been going on since 2021, ultimately forcing state lawmakers in 2024 to approve a map that includes a second majority-minority congressional district. The seat is now held by Democratic Congressman Cleo Field. The case, Calais versus Louisiana, first reached the U.S. Supreme Court earlier this year, and in a rare move, the justices declined to issue a decision, instead ordering the case to be re-argued this fall.
Looking at a very, very monumental hearing, rehearing actually, Supreme Court decided when they originally heard the arguments, they were not going to rule on the issue at that time.
A constitutional clash over voting rights. At the heart of the dispute lies a fundamental tension between competing constitutional principles. Section 2 of the Voting Rights Act of 1965 prohibits voting practices that discriminate based on race or color, ensuring minority voters can elect their preferred candidate. However, the 14th Amendment prevents states from denying citizens equal protection under the law, while the 15th Amendment states citizens cannot be denied voting rights based on race. State Senator Thomas Presley argues the current map is unconstitutional because it's based solely on race. He favors districts drawn around regional commonalities rather than racial demographics.
It doesn't matter if you're black or white or purple or green. You have those commonalities of interest. And I think that's what we should be looking at when we're looking at redrawing districts.
The current map spans diverse regions. The disputed congressional district stretches from Baton Rouge through Lafayette, Alexandria, and Natchitoches before ending in Shreveport. Senator Presley contends these different regions have varying interests that shouldn't be grouped together.
I believe that's accurate. I believe that's what we should be basing our redistricting maps on, and ensuring that everybody has equal protection under the law, and that we are certainly pushing for a colorblind society.
It's high stakes for minority representation. Louisiana's population is 1/3 African American, which supporters of the current map cite as justification for the additional majority-minority district. Currently, only 2 African Americans represent Louisiana in Congress, while the other 4 representatives are white. They are Speaker of the House Mike Johnson, Steve Scalise, Clay Higgins, and Julia Letlow. The Supreme Court's ruling could jeopardize both existing majority-minority seats, and Representative Jackson warns that depending on the decision, a new map could eliminate the seats held by both Fields and Congressman Troy Carter, Louisiana's only other Democratic representative.
There could be a map that could take away his seat. There could be a map that could take away Congressman Fields' seat. There could be a map that could basically just merge that seat together.
Carter echoes those concerns, noting the national implications of the case.
It could eliminate seats across our country where African Americans are currently serving.
The Supreme Court's decision will have far-reaching consequences for minority representation and redistricting practices nationwide. All right, about the legal battle, Louisiana Attorney General Liz Muriel says in part, quote, "I am grateful that the court has now asked the parties to brief whether this entire system is constitutional. My answer is, it is not. Our Constitution sees neither black voters nor white voters. It sees only American voters," end quote.